Any mention?
May I please, Your Lordship? I beg to mention item number 13.
13.
I humbly pray let this matter taken up after 2 weeks, Your Lordship.
You are mentioning on behalf of?
As Deb.
Yes, Deb.
Yes, Your Lordship.
I have no.
13 as well as 14, Your Lordship. 13 and 14. Connected matter.
14 also you are there.
No, I'm not there. Only 13.
Who is 14?
Mr. Kharmi is there. I'll inform him.
You will not have any objection.
Connected matters.
Connected matters. Okay, 13 and 14. The prayer has been made by so and so on behalf of the petitioner to adjourn the matter.
After 2 weeks, Your Lordship.
Adjourn the matter for 2 weeks.
So blessed.
Prayer has not been objected by the counsel of the respondents. Prayer allowed. Please.
May I please, Your Lordship?
Yes.
Your Lordship, I beg to mention item number 11. I'm praying for 1 week times, Your Lordship.
You are appearing for?
Petitioner, Your Lordship.
Petitioner.
Lordship, one for the state.
No objection.
Lordship, no.
This is also a 2019 matter.
Yes, Your Lordship. 1 week times, Your Lordship.
As prayed for by the learned counsel of the petitioner. This is matter after 2 weeks.
Bless, Lordship.
May I please, Your Lordship? I beg to mention item number 10.
10.
Yes, Your Lordship.
On behalf of
M. Kurishi, Your Lordship, petitioner.
petitioner. Petitioner, go to that side. You are the petitioner.
I'm for respondent number 6, Your Lordship.
State is also a party.
Lordship, I'm appearing on behalf of respondent number 7.
Your Lordship, the conducting counsel is not well. He's suffering from cold.
Who is appearing for the state in this? This is a writ petition, isn't it?
H. Kharmi, Your Lordship.
I'll inform you, Lordship.
We inform him, but then we do not know whether a mention has been made on behalf of the petitioner on the ground that the counsel appeared for the petitioner is not well. For adjournment of the matter by 2 weeks. The prayer has not been opposed by the learned counsels appearing for the respondents. Prayer allowed, list after 2 weeks. This is item number 10.
My Lord.
Yes.
My Lord, I beg to mention item number 4, my Lord. My Lord, that is the matter where the SLP is pending, my Lord. That's forthcoming in the month of September, my Lord. Notice has been issued to the respondent, my Lord.
Oh, that matter, that movement order.
My Lord, movement order has not been issued to the petitioner is neither there, neither.
I don't know who.
I'm for the respondent, Lordship.
This will be dependent on the outcome of the apex court decision. The Mr. Arjal, learned counsel for the petitioner, submits that the connected matter pending pending before the apex court is still pending, and
My Lord, in the month of September it's
is
coming.
likely to be listed in the month of September. Learned counsel prays, and in view of that, he prays for an adjournment. Just continue on, don't give. And in view of that, prays for an adjournment for the matter by 4 weeks.
Moment.
By another 4 weeks. The learned counsel for the respondent has not opposed the prayer. List this matter after 4 weeks.
Highly obliged.
Your Lordship, I beg to mention item 6 on behalf of Mr. H. Hazarika.
What happened to Mr. Hazarika?
Lordship, he requires some more time to prepare the matter.
Mr. Nath?
I'm appearing for the petitioner.
No objection.
So, since they are saying not prepared.
It's a service matter.
Yes, it's a quite old matter, 2016.
I'm appearing on behalf of respondent, Your Lordship.
Ms. Thungwa, another government advocate, makes a prayer on behalf of the respondents on the ground that Mr. H. Hazarika the learned government who is appearing the matter is not well. She makes a prayer for adjourning the matter by 2 weeks. Learned counsel for the petitioner has no objection. Prayer allowed, list after 2 weeks.
Highly obliged, Lordship.
All right.
May it please your Lordship. Lordship, I beg to make a mention of item 12.
Yes.
Lordship, I'm praying if we, for some more time, Lordship, we are yet to file our written arguments in this matter, Lordship.
We have not heard you.
Lordship,
So where is the question of filing a written argument at this stage?
Lordship.
We'll first hear you, and if in case required, then only you'll file written argument.
Lordship. Lordship, I'm praying for some time.
On behalf of the
On behalf of learned counsel, senior counsel, Kipol. On behalf of the respondent, Lordship.
I'm for the petitioner.
no objection. No objection.
Lordship will go through the order sheets. So much adjournment has been granted.
All the matters before this court, situations are similar. There is no difference.
Otherwise, I'm
If
ready.
you have objection, definitely we will not adjourn it. We will hear it. We will proceed to hear it.
Last chance. Lord.
There is nothing for last chance.
Since she's not ready and the senior also is not here.
Write her name. Appearing on behalf of the respondent. Prays for adjournment of the matter by 2 weeks. Learned counsel for the petitioner has no objection. List after 2 weeks.
Obliged.
Highly obliged, Lordship.
Mr. Mujika is here. See the last item number 15. Is it concerning the education department case?
Lordship, this is quashing Lordship. It's concerning that only.
This education
Case,
department.
Lordship.
That teachers camp.
Lordship.
This cannot
Here,
be before this.
Lordship.
List item number 15. List this matter before any other bench without me. Because I played a part at the time when those original matters started. So,
Deeply obliged.
May I please your Lordship, I beg to mention that item number 8, the conducting counsel, senior advocate S.P. Mahanta is indisposed. So I pray for the matter to be listed after 4 weeks.
number 8.
Yes, my Lord.
Lordship, 8 and 9 are connected matters. My learned friend is appearing for 8. I'm appearing for item number 9.
For the respondent.
I'm for the petitioner.
For petitioners. Mention has been made on behalf of the
On
respondent.
behalf of the cantonment board, my lords.
So in 9 also cantonment is the respondent.
The connected matters.
What is to be done? He is not well, that has been said.
And he informed me in the morning, my lords.
No objection. No objections. Item number 89. A prayer has been made on behalf of Mr. S.P. Mahanta, Learned Senior Counsel, on the ground of his ill health, to adjourn the matter for 2 weeks. 2 weeks?
4 weeks. 4
Huh?
weeks. 4 weeks.
4 weeks will be too long.
He's under
Is it not?
medication.
If it is for 4 weeks, then I think we'll have to go and engage somebody else. Make it 3 weeks. The learned counsel for the petitioner has no objection. Prayer allowed, list after 3 weeks.
Oblige your lordship.
Main list, item number 1.
Me, please, Your Lordship.
Yes.
Lordship may kindly take up this matter at the end of the board, Lordship. The learned
Trial of the
DSJ is
board.
on legs.
Okay. Call it up.
Highly obliged. Much.
Item number 2.
May I please your lordship?
Yes.
Lordship, in this matter, already talks of settlement is already going on between the parties, lordship.
That is perhaps a submission which has been made in the last 2 occasions.
That part we know, lordship. We have already contacted the respondent side to come down to Guwahati, as the petitioner is indisposed, lordship. If we allow, then we can enter into the agreement, lordship.
It takes so many dates, so many adjournments on the ground of compromise.
Lordship.
But after all, if no compromise is attained, then it is unnecessary, you see, adjournment.
Lordship.
You should proceed.
Well, from my end,
benefit of the case.
everything has been done. My lord, the only problem here is that, my lord, from their end, at least we've been very, very considerate. In fact, we have even cut down the amount also. We're not asking any amount of interest. This money was taken in the year 2017. Well, this old lady worked her entire life. She retired from private service working outside the state. Came back over here with a view to start a business. Invested all her earnings. But my lord, the entire money has been, now it's nowhere to be found. Well, it's a clear case of fraud. Well, even though we have initiated, filed a money suit in the trial court, we've also filed a criminal complaint because we say a case of fraud is made out. Now, when they come to make an offer for a settlement, we are okay with that. At the end of the day, this old lady wants her money back so that she can use it for her children or whatever purpose. Now, my lord, a warrant was issued. Thereafter, they come before this court saying that it's a civil dispute. Court is pleased to stay the matter, saying that the parties are willing to compromise. Well, it's been 5-6 months. No steps have been taken
Lordship,
on one pretext or the other, my
to
lord.
submit one line, lordship. Lordship, a date may be fixed. If it is not settled till that date, then we shall certainly proceed with the petition, lordship.
See,
A last chance may be given, lordship. I would humbly pray before your lordship. If we do not come to a settlement, then certainly we will proceed with the petition, lordship.
the learned counsel for the petitioner has again renewed the prayer for adjournment of the matter. On the ground of attaining any, on the ground of arriving at a solution for amicable settlement in the matter. With the respondents. The order sheet reflects that the matter was adjourned on earlier occasion also on the basis of the same prayer. Stop. The Mr. Gautam, appearing with the respondent, submits that in spite of adjournment on several occasions, till date, no settlement has been arrived at by the parties. Stop. However, for the ends of justice, the petitioner is on the ends of justice, the matter is adjourned. Once again, to enable the parties come to an amicable settlement. We should stop. It is made clear that if no settlement is arrived at, the matter will proceed for hearing on merits.
Lordship, if a date is fixed, I will be highly obliged.
This will come after this thing. See, we are not giving this thing. This list is matter after 2 weeks. You'll get 2 weeks.
2 weeks, Lordship.
Make sure if you are serious, you do it. Otherwise, you
Much
will.
obliged. There was an interim, Lordship. If it is continued, on 10th of March, there was an interim. On the
But
last
then there is no.
quotation,
It has not been continued to the last order also. It is going on now.
I apologize
That
for
order
that,
is
Lordship.
still in existence. It need not be reflected, Your Honor. We're not pressing it also. It's not.
Much obliged, Lordship.
Item number 3.
Lordship, I have a humble prayer, Lordship. If the matter may be taken up at the end of board, senior counsel is on legs.
Then let DB on at the end of the board. Call it again.
Obliged.
Item number 5.
Yes, Malad. Again, Mujika, Mr. Mujika.
Lordship.
This also has to come, or you can do matter things.
Lordship, I don't have any instruction.
This is also call after subtypes. Next matter.
Item number 7.
My lord, this is for grant of ACP and non-ACP. My lord, on the last one, I have to file a written argument. My lord, I am filing today.
But then without
on the
hearing the matter, what written argument?
My lord, the previous bench has heard, my lord, and directed to file a written.
List it after 1 week. You file a list.
But
On the prayer of the petitioner, list this matter after 1 week. We are not recording that we will file a written agreement. We file it because I have not heard. Where is the question of passing any order?
written argument is ready, my lord. But anyway,
It's okay. You place it on record. We'll just
my
see
lord,
it.
I will place.
Highly obliged.
There's no other matter. Hmm? Call, you have to call.
Second call. Item number 1.
Yes.
Lordship, the learned double AG is still on legs. So,
Both the council are on legs.
yes, Lordship.
We'll pass it over tomorrow.
Lordship.
Pass over for the day.
Lordship, right, Lordship.
Item number 3.
Lordship, senior is still on legs. Lordship, in this.
You are there, you can do it.
Lordship, in this matter, we're supposed to file a rejoinder because the respondent no two not file an affidavit.
This is 482 application.
Lordship.
This
They
will
will
go like a
grant-
writ petition and you will file rejoinder, then file answer to your rejoinder.
Lordship, liberty was granted to the respondent number 2 to file an affidavit, bring on certain records.
482, normally it has been done. Shokos is done. See, Shokos is allowed.
Lordship.
Because
They file a detailed affidavit which requires response from our side, Lordship. It's almost ready. We're filing in the course of the day.
This way where it will end up. What is the matter about?
Lordship, this is relating to the supply of the PHE pipes, GI pipes under the PHE department. There's certain allegations between the petitioner and respondent number 2. Now, certain FIR has also been lodged before Calcutta, Your Lordship.
There is
Now
a
that FIR has been filed by us.
before NCLT also, National Company Law Tribunal also. There is a proceeding.
Lordship.
Then FIR in.
FIR was lodged by us, Your Lordship. Then, as a counterblast, the respondent number 2 has filed the FIR before Joy PS on the same subject matter, Your Lordship. Now the FIR which was filed by us in Calcutta, that is still pending for investigation. Now as a counterblast to that, they had filed another FIR in Joy PS. So we have come to for quashing of the Joy PS FIR, Your Lordship. Now they have filed an affidavit, bring on record certain developments and certain allegations which we...
They means like the state. You are
No, not the state,
Your
the
Lordship,
private
Miss,
respondent.
Mr. Andy Shula is appearing along with Miss Colney, Your Lordship, and they're both on legs, Your Lordship, in court number 3.
Anyone appearing for private respondent? There is private respondent.
Mr. Philemon Nombri is also on legs, Your Lordship, in court number 3.
Mr. P. Nombri is appearing for the... Philemon Nombri is appearing for the private respondent. Who's the informant of the FIR in question?
Oh, it seems the court has allowed you to file.
Lordship, as per the previous orders.
Yes, this court has decided to quash the FIR without hearing you. Since you are absent.
Another matter just started, my lord. Another matter just started, my lord. So, the first call we were here, he sought for end of the board, my lord. 2 minutes at the end of the board reaches, my lord. So,
No, you have to arrange it. You see, this is the way court
yes, my
works.
lord. I left that matter and came, my lord. I have to say something.
We'll file it positively within the...
See, there is an order allowing them to file rejoinder to your reply to your.
Yes, yes.
So they have not done it.
Yes.
So now these 482 applications are becoming like a writ petition, where you file everything and that it is counted by petition. Okay. So anyway, whatever the thing, since there is an order already allowing them.
Reason being, there are certain facts which were to be brought on record.
See, 482, when there may not be a very detailed examination.
Not detailed, my lord, but it was
Only
necessary.
we will see to the confined to the FIR and we will just see.
Yes.
What is.
Counter FIRs.
Anyway. Affidavit in response to the affidavit filed by the association. Hard Mr. Non-pure learned counsel or the petitioner who submits that the petitioner is yet to file a reply affidavit. As per order dated 24/7/2023 passed by this court, and prays for allowing him some more time for filing the same. No objection.
No objection.
No objection, Your Lordship.
Lordship, I have one more prayer, Lordship. If the matter may be fixed on 5th September, my Lordship, the senior counsel from Calcutta is appearing, so he's requested for this particular date, so I can come.
Take the date and tell him to come on that day.
On 5th, that is my humble prayer, Lordship, on 5th September, after 2 weeks.
First, you see what date is fixed by the court master, then you inform him, let him come accordingly.
Lordship.
September.
4th September.
We do not know 5th September what it be.
4th September, sorry, Lordship. 4th September. 4th September.
What was the thing last? No, just last line, just you say, he prays for. You have not read out some part in the middle, isn't it? Okay. No, not in the between. In between. This is identified a reply affidavit. This is. The learned counsel for the respondents have no objection. Prayer allowed. As prayed for, list this matter on 5th September.
4th September.
4th September.
4th September.
Okay. On 4th.
Item number 5.
My lord, here it's a dismissal on the ground of AWL, absent without leave.
Very serious offence, eh?
My lord, a little serious. I'm here challenging the impugned order of dismissal on the ground of procedure has not been followed, my lord. So they have
What
supplied
is
me
the consequence of non-adherence to the procedure?
the.
Does it cause prejudice to you?
It is, my lord. The very able to defend myself. That goes, my lord. They have supplied.
Give me the facts.
My lord.
Let us see if Mr. Majika comes here.
My lord, the petitioner was enrolled in BSF, my lord, in 3rd December 1997, my lord.
Madam, you sit down.
3rd December 1997, and he was performing his duties there. He was granted with a
Enrolled as BSF
as constable, my lord. As constable, my lord.
on 3rd December
1997, my lord. Constable GD, man, general duty.
3rd December
1997, my lord.
Where is this order?
My lord, that
have not
enrollment is not.
There is a statement.
My lord, I made a statement, my lord.
Okay.
My lord, it is at page.
It's all right, no problem. Proceed.
Page 4, paragraph 3(1), my lord. Page 4.
It's all right, yes. Go ahead.
My lord. The petitioner was placed under low medical category, my lord, shape 3, my lord. And owing that, he has obtained for the leave of 60 days, my lord.
As per entitlement, it is. He is entitled to take that.
Yes, my lord. He is entitled. 60 days leave for the said purpose.
From when?
With effect from 26th May 2014, my lord. But he was granted only 15 days, my lord.
Achha. So, he applied for leave.
He applied for leave for 60 days. He was granted only 15 days.
Yes.
11, that was with effect from 26th May 2014 till 11th June 2014.
26 May. 14 to?
My lord, 26th May 2014 till 11th June 2014. Man.
But it's more than 15 days.
Man.
Now
Plus
how the leave was?
plus 2 days journey period is there. Man.
So 2 days journey period is not included in your leave.
It's no. That's
It is a rule.
Apart from journey period, my lord, it's even on transfer or on leave. Journey
Transfer, okay, certain time is given.
Man.
But then on leave also it's given. No, I don't think.
No. That's right.
How can your journey time be given on leave? No, what was they granted leave for 15 days with effect from which date to which date?
My lord, on 26th May.
For 15 days.
Man.
(2014). Okay, and then.
My lord, when the petitioner
went on leave, and then when did you come back?
My lord, I have been. I came back in the. My lord.
When did you come back, and when did you report for duty, rejoining?
Rejoined on 1st August 2014. My lord.
June, July, August. Okay. You overstayed leave.
My lord. With a sufficient cause.
It's okay. We'll just see. The causes will determine. It's just getting the
facts.
You rejoined on 1st August.
Mal.
2014 or next year?
2014.
And then you were allowed to join.
My lord, I was allowed to join.
And then?
My lord, the respondent authorities, my lord, has issued a letter dated 23rd August 2014, my lord, Annex 3, my lord.
That is?
My lord, at page, my lord, 21.
Yes.
That was.
So means after joining, you have filed an application.
My lord, again, for
regularizing your leave.
Leave, my lord. But they have discarded. And, my lord, as per them, court of inquiry was constituted and ROE was recorded. Means ROE after that summary of evidence, my lord. After court of inquiry, summary of evidence was recorded, and which culminated into constitution
after
of.
Court of inquiry, there is a. Just explain that, but I do not know that.
My lord, court of inquiry is a fact finding, my lord. Why it was, why delay was there, why you have not joined, sufficient cause has. Though the court of inquiry has not been annexed by them, my lord. In the ROE was recorded, my lord.
What is ROE?
ROE is recording of evidence, my lord. After the court of inquiry.
Recording of evidence is not a part of.
No, my lord. That's court of inquiry is a different, my lord. After the court of inquiry, my lord, it is placed before the commandant. Then the question of hearing of charge is there, my lord. Before the court of inquiry, after the court of inquiry, my lord, a tentative charge sheet. As a general key, it was placed before.
Where do you get these procedures?
My lord, it is under the BSF Act rules.
What is the provision of rule?
My lord. My lord can come to page rule 43 even. Rule, yeah.
This offence report.
My lord, offence report.
Now, overstaying in leave is an offence.
It is. It is. It's a.
It is punishable.
It's a punishable.
It is punishable as an offence.
My lord.
There is no difference between, you see, like inflicting departmental punishment.
It is there, my lord. The departmental punishment. It's they have assigned under. It's a. There are various kinds of punishment, my lord. Dismissal from service, reduction of rank.
Who is subordinate officer? It says where a person subject to the act other than officer or subordinate officer. What does it mean?
Subordinate means over other ranks like constables up to the JCO level, my lord.
So you are also constable?
Yes, my lord.
So this 43 doesn't apply to you?
43.
Just read it. What does it say? Now, if you say you come under a subordinate officer, then this 43 is not applicable to you.
To me, no.
Then you are referring to 43.
My lord, it's a procedure I am referring, my lord. My lord,
knowing the ignorance of the court, so you are
no, my lord. No, my lord. It's not my duty to mislead this honorable court, my lord. My lord, 45, where the charge sheet. 45. There is nothing on the affidavit that the offence report has been prepared by them.
Now, that is charge sheet. Is it not that the 45 would apply to person those who are
hearing of charge, my lord? Even if we say that if the 43 has
where
been
is the charge? Come to the petition. Where is charge against you?
My lord, in the impugned order, my lord.
Where is that?
My lord, Annexure 8, page 37, my lord.
What is it? 30 total?
305 days.
305 days.
They say, my lord.
How can it be?
They, as per them, it's 305 days. My lord, here they say that accused.
You joined in 2015, not in 2014.
My
That
lord,
is what? You joined in, as per them, you joined on 12/4/2015.
as per them, my lord.
Now, what you said that you rejoined on 1/8/2014, it is not correct.
My lord,
then.
23rd August.
What is the 23rd August? No, it doesn't show that you have rejoined. It doesn't say you have joined. This has happened consequent to you think. It is through communication only. If you fail to establish that you have rejoined on 1/8/2014, you have no case. You have no case.
My lord,
Yes.
Lordship, in page 4 of our affidavit in opposition,
Yes.
Lordship, para 8. Para 8.
8, yes.
Lordship, that after lapse of 49 days overstayed period, the petitioner sent an application dated 31/7/2014.
Yeah, there is an application. That is what I am saying. It is by communication. He has not joined, isn't
Yes,
it?
Lordship. And
He had not joined.
on 1st August 2014, he applied for extension of his leave on medical ground.
Yes. If that be the thing, then was it extended? Okay.
Lordship, he was directed to resume his duty.
Forthwith.
By letter dated 23/8/2014. Lordship, may kindly take up this matter after 2 weeks, Lordship.
You are doing well. Why you? Hmm? You filed a rejoinder. Did you refute all those things?
My lord, I have refuted not in verbatim, my lord, not specific, but I was on the law point.
If there is no rebuttal on specific, then there is no rebuttal at all. Evasive rebuttal is no rebuttal at all in law. It seems you are not
Basically, my lord, I've been on the law point. I was because non-compliance of.
Just give us what is the law point.
My lord, non-compliance of Rule 45. My lord.
What Rule 45 says?
Hearing of charge, my lord. By the commandant.
If charge stands admitted, is it required that charge should be heard?
My lord.
If certain charge stands admitted, is it required that
Admitted by the accused.
By the delinquent, the against whom charge is made.
My lord, even the procedure, my lord. During the then also, my lord, 130.
As per Rule 44, once allegation is reduced in writing, that becomes charge sheet.
Mal.
We'll not decide without Mr. Mojika, so don't get worried. We'll just let me get the things. This is like conducting an inquiry, see. Yes. That has not been done. No inquiry was conducted.
No. Hearing, not, my lord. Inquiry was at a different, my lord. Once the court
the hearing of the charge has not been.
Not been done by the person concerned who is competent, my lord.
No. You see, if you see the Rule 44,
my lord,
it speaks about
charge sheet.
It speaks about commission of offence by
my lord,
subordinate officer. That means you and all. 43 is not coming to you. 44 will apply to you.
My lord, charge sheet.
Yeah.
My lord.
Now, moment this allegation is written into writing, that becomes a charge sheet.
My lord. Tentative charge sheet.
So it means charge sheet comes prior to inquiry.
By an inquiry. And that charge sheet has to be heard by the.
Okay. And then thereafter, then what happens after the hearing of the charge sheet? Then,
my lord, then the commandant applies the mind, my lord, either based on the court of inquiry or that based on which the charge sheet has been there, my lord, or by calling the witnesses, my lord.
See surplus 2,
My lord.
45.
My lord.
After hearing the charge, under surplus 1, the commandant may award any of the punishment which he is empowered to award.
My lord. Or dismiss the case.
Yes, so may dismiss it.
My lord. Or
It depends upon what comes out in the
hearing
of charge.
My lord.
Now you have not been heard.
No.
No, at no point of time that has been followed.
No.
That is the case.
Directly they constituted a security force court, my lord. That by which I was dismissed from service, my lord.
No.
Security
If
force.
if matter is remanded to security force court,
My lord.
without hearing on charge sheet, and in the security force court, what is the procedure taken up?
Security force court, my lord, the procedure.
Which way it proceeds?
It is like a trial, my lord. It's evidence.
It's like a departmental trial in any other department.
My lord.
So same thing. It's like that's
My lord, here the very 157 rule, my lord.
Yes.
In the security force court, my lord.
157, rule 157.
My lord. Friend of the accused, my lord. Either friend or a defending officer in the defense assistance in the civil, my lord. That has not been provided.
See, what is the language may take?
My lord.
Now, may take means you have to make a prayer for that. You should not say shall take. Taking assistance is by you. In security force, I don't think will lend you any assistance. It is for you to do it.
My lord, that
now, if you do not do it, it is not something like that you wanted to take assistance and the security force court did not allow.
My lord, that I being the petitioner being a layman, my lord,
Can it be excused in law? You know the well settled proposition of law. Ignorance of law can
that's not an excuse, my lord. That's admitted, my lord. That's admitted fact. But my lord, after considering the legality, my lord,
see the language is very much clear. During a trial at a summary security force court, an accused may take the assistance of any person, including a legal practitioner, as he may consider necessary. Department is not under obligation to provide it to you. If you want it, you take it. If they prevent it, then it becomes a violation of your right.
at a option would also from the if it is an accused, my lord, because they have termed an accused to the petitioner, my lord.
Yes, because there is accusation against you. I don't think that 157 at no point of time, until unless you can show that you basically opted for that and it was refused, or your defense assistants, whomever you have taken together, was not there. But then the law is very much clear, saying that even if you have a friend with you or legal practitioner, they cannot address the court.
They cannot, my lord.
They can
So
only
that's
provide help.
that's no use of, my lord, the provision as a safeguard.
So this is the only two things.
My lord, the proceeding which they have provided, my lord, after so many years, my lord, it shows that even that non-compliance of there was no interpreter, my lord, interpreter, because it was recorded in English. Petitioner is not aware. So in which sense that proceeding, my lord, they have given me. So that says that nothing, no interpreter, nothing is there, my lord. And simply say that I am guilty, my lord. I have pleaded guilty.
Where does it say that you have to have interpreter?
134,
See, if you-
134.2. Rule 134.
Okay, I will just see. One 34. What's it?
134, my lord. When the evidence to be translated.
Evidence when to be
Right.
translated.
When
When an
any-
evidence is given in a language. Yes, yes. Go to. Yes, please.
My
go.
lord, when the evidence is given in a language which the court or the accused does not understand that evidence language shall be translated to the court or the accused as the case may be in the language which he understand. 2, my lord. The court shall, for this purpose, either appoint interpreter or shall itself take on oath or affirmation prescribed as an interpreter. Shall.
At a summary security votes.
My lord, shall.
That is okay. There is only once. See, subclause 1, subclause 2 has to be read together. Okay. When the language requires translation, then only the subclause 2 will come. If it
My
is
lord,
not, then there is no question.
It's entire.
Okay. Now, on what basis you say that has to be? You say like that the provision would become mandatory. When?
My lord,
So
mandatory.
there has to be basically either expression by the. If you talk about confine yourself to the accused, then accused has to say that I do not understand.
My lord, that-
And it should be translated to the such and such language. Now, where is that? Without yourself pointing out that you do not understand, how a person will know that you do not understand? You remain in a duty for certain times. You have come, Mr. Mojika, probably I have to rise again. I do not know. Now we have proceeded with the hearing in your absence. We started to just, we wanted to know that.
We'll resume after DB.
You can do that, but then until I get a call, I'll be continuing. Mr. Jha is placing, so nothing to worry. Mr. Jha is placing his case. Yes, so this 134 will be operative when you make an expression that you do not understand the language.
My lord, it's English. My lord.
That is okay, but then how do you know you do not know English? Is there any presumption?
My lord,
A person, if he studies, say like me, till date I cannot speak English properly. But then there are people who have not studied cross class 10 also can speak very good English.
That's
They have that background matters. So it is, there is no presumption that you will not understand English.
As
The
it
only
is.
thing I do not know, so far as 134 and 157 is concerned, I am not very convinced. But then that 45,
45 is.
that Mr. Mojika will
45 has.
Mr. Mojika will answer. 45. Then you will take us to the details of the facts. We have not taken the facts, details of the facts, but then your case is simply is that you went for
leave.
15 days leave was granted plus 2 days journey time, and you came back after 1 year.
Lapse of.
There is a delay of 5 days. 5 days. Okay. Now you claim that you have joined on 1/8/2014. There is nothing on record to show that you have ever joined at 2014. So that is what we'll resume after finish the. There's no difficulty on your part to continue with this hearing.
Though I'm not fully
If
prepared.
both of you are prepared, then we'll come back and we'll sit. I did not fully prepare this case, Madam, today. Of course, there is nothing much to be prepared by you also. Once you know the facts, you can do it. Anyway, it's up to you. But then, since if you want an adjournment, we can do that. Of course, provided Mr. Jha agrees.
No, can.
And it seems Mr. Jha also is not very prepared.
On the law points, it was there. Man.
I can understand from the way of presentation. We have some other matter after this. All adjourned.
Sir, might he submitted, sir. Might he give a submission regarding affidavit.
So we'll have it after 2 weeks. On the prayer made by both the parties, this matter, release this matter after 2 weeks.
It's possible for the day. It's coming tomorrow.